Hi, I'm Emily from Weichert Realtors Lake Point in Madison. Your home, your property, your decision. At Weichert Realtors Lake Point, we'll guide you every step of the way, whether you're buying or selling a home or exploring commercial property. Your dream is within reach. You'll find our realtors love what they do, and more importantly, we think it's fun helping our clients achieve their goals. Who wouldn't want to do that every day? Give me a call at 608-721-8002. Weichert Realtors Lake Point, 2045 Atwood Avenue. Find more info at weichert-lakepoint.com.
There's a small Wisconsin town where the population grows to 10 times its size every February.
Normally, we're about 2,600 people. During Berkey Week, that gets up to 30,000.
That's Blair Flickinger with the Foundation for the American Birkebeiner. The skiing marathon started with a couple of people carving a trail between Hayward and Cable 50 years ago. It's also a tribute to the ski culture of another country already hosting its own Birkebeiner. Is it Turkey, Norway, or Germany? The answer coming up.
There's a camaraderie that comes along with this event that is unparalleled.
A camaraderie between people who come to Hayward from around the world.
Make everyone feel like Hayward is their spot for the week.
So did you guess the Berkey was created as a tribute to Norway's 100-year-old race? And while our Berkey is a well-known winter event, it's still growing by adding other races all throughout the year. There's a slice of Wisconsin. I'm Terry Barr for the Civic Media Radio Network.
You know, I hope this is the best hour of your life. I'll tell you that. The Cripes Cast, folks.
Comedian Mary Mack.
He's noticed a very sizable increase on people off the lake coming onto our lake to fish it. You don't want everything to be popular and known about. That seems to be the way I also approach my comedy, Charlie. I think there's a theme.
Cripes Cast every Saturday and Sunday at noon across Civic Media and on the Civic Media app.
Keeping Southeast Wisconsin informed, engaged, and entertained. This is The Shaw. 540 AM and 101.1 FM. WAUK.
Discussion now this morning on our Saturday morning broadcast of this major RICO prosecution pending in Fulton County in Georgia, alleging that Donald Trump and about 18 other people engage in various acts, a wide sweeping set of charges there involved with attempting to undermine, to affect, to influence, to distort, to steal the election in Georgia based upon the legitimate votes cast by Georgia voters. A very broad indictment there brought by Bonnie Willis. She is the prosecutor in the case, but returned by and charged by, important point, two grand juries. One of them an investigative grand jury under Georgia law. The second one an indicting grand jury. Very important point to understand in our federal system, certainly in many state systems as well, including there in Georgia, that the prosecutor is responsible for prosecuting the charges, the cases that are returned or issued by a grand jury. And what is a grand jury? A grand jury is a group of people, typically about 25, 26 people, who are brought together from the community. They're not prosecutors. They're not necessarily lawyers who review evidence and determine whether there's probable cause to believe that a crime has been committed. And that's exactly what happened in Georgia a number of months ago. And in the wake of that review by this grand jury of the evidence in Georgia there, the grand jury returned this very broad, sweeping indictment. And in the wake of that, one of the defendants, his name is Michael Roman, he's one of the 19 charged with violations of RICO there, has brought a motion. He has brought a motion seeking to disqualify the prosecutor, Bonnie Willis, and yes, indeed, one of her co-prosecutors with whom Bonnie Willis has also had a personal relationship. His name is Nathan Wade. And Roman is seeking to have them disqualified from the prosecution of this case. And so we're going to spend some time this morning pulling apart the notion that is again, it's an applicable to cases if indeed disqualification is appropriate. But the notion under these facts that Bonnie Willis should be disqualified, completely unfounded, completely unsupported by what we have seen, not only in the pleadings, but especially in the hearings of the past couple of days. You know what this is all about. The allegation is that Bonnie Willis has brought onto the staff this fellow named Nathan Wade. And depending upon what the evidence is or does not show, the nature of the relationship, when it started, when it ended, those kinds of things, all matters of the review in the evidentiary hearing of just the past couple of days. But along the way, Mr. Roman, through his attorneys, alleging that the alleged romantic relationship between Willis and Wade, the financial compensation that Wade received as a special prosecutor, even things like the trips, the travel with Wade and Willis while they were together romantically, that those kinds of things have an impact upon the prosecution of him, and therefore that they should be disqualified. Indeed, the entire office should be disqualified for that personal behavior. Now, let me say at the outset that I have never, as a supervisor in a prosecution office, including my 6.5 years as U.S. attorney, I have not been an especially big supporter of these relationships inside offices. Not that people can't have personal relationships, but the relationships can indeed cause problems. And indeed, there's no doubt that the relationship here between Nathan Wade and Fonnie Willis, which is apparently now over, has brought attention to them personally in a way that's a diversion from the principal focus, which is the prosecution of Donald Trump. And it resulted in a 2-day, a border-to-border, 8 o'clock to 5 o'clock hearing in front of Judge Scott McAfee, who's presiding over the criminal prosecution. He entertained evidentiary presentations by various witnesses, including Nathan Wade, including Fonnie Willis, about whether this personal relationship qualifies as a basis, a factual basis, to disqualify Fonnie Willis and the entire office from prosecution. Couple of things related to this, and that is, number one, fundamental notion that defendants do not have the ability, do not have the capacity, do not have the right to choose their prosecutors. And as I said, there certainly are things related to the personal relationship here, maybe in other cases as well, that need to be addressed. But those are matters for internal issues inside the district attorney's office, and they do not impact and should not impact going forward with the prosecution. Let's talk about this in particular. Under Georgia law, even if all the factual allegations that are set forth about the travel, about the payments, about the nature of the relationship, all the other, I would present, irrelevant things that have been said during the course of these hearings of the past couple of days, let's assume all of those are true. There still is no basis for Judge McAfee to disqualify the office and Fonnie Willis from the further prosecution of this case. The key point is that regardless of those factual circumstances, the matters related to hiring and the timing of that, the relationship, all of that do not affect the propriety of the prosecution against Roman and his co-defendants, including Donald Trump. Questions, for example, about gifts, related matters go to Willis's and Wade's obligations to the DA's office. And in that connection, they have no connection to assuring the defendant, in this case, Mr. Roman, presumably the others as well, a fair trial. The allegations, the things we heard about in the past couple of days, all these facts are interesting. They are related plainly to personnel, HR, human resources matters inside the office that need to be addressed, that certainly are a diversion, that have got now the entire nation focused upon this issue and not the principal issues, which are the prosecution going forward of Donald Trump and the others. But the fundamental presentations do not have this connection to ensuring a defendant, including Mr. Roman, has the fair trial presented to him. He's got a right to that. It's not related to these particular personnel issues. There is irrelevant to the trials allegations, for example, in other situations that, for example, prosecutors took supplies for personal use, office supplies, if you will. Let's suppose they drove some county vehicles on personal errands, even did things inside the office that relate to interactions with their coworkers. All of those are legitimate issues. They're legitimate issues for the prosecutor's offices internally to deal with, and things that need to be addressed by virtue of the oversight responsibilities of supervisors inside those offices. But those allegations, those kinds of things, personal matters, relationships, monetary matters that do not impact the most important prosecution itself, they do not affect the criminal prosecutions that require them to stop or be suspended, certainly not being dismissed, and do not justify the removal of the prosecutors themselves. Let's talk about what Georgia law says and what it does not say when it comes to prosecutorial disqualification. It's actually exceptionally narrow. And their allegations, the allegations here do not fit in any of the categories in Georgia law under which Fani Willis could be disqualified. Again, the focus of the claims by Mr. Roman: alleged romantic relationship between Willis and Wade, some financial compensation that Wade received as a special prosecutor, and this personal travel that Willis and Wade took together, other related things along the way. Two generally recognized grounds for disqualification in the state of Georgia. The first is a conflict of interest, which we'll talk about more. And the second is forensic misconduct. What is forensic misconduct? That's doing things like going out and creating evidence that does not otherwise exist, falsifying records, suborning perjury, those kinds of things that would prompt you to say there is a real miscarriage of justice here. It would not only have you taken off the case, but probably have you disbarred, maybe even prosecuted criminally. Misconduct in terms of managing the evidence and doing things that are meant intentionally to undermine the legitimacy of the prosecution. No allegations here whatsoever of any forensic misconduct whatsoever. And so what about a conflict of interest? What about a conflict of interest? Does that exist? Well, there are such things as conflicts of interest out there. A conflict of interest, again, in Georgia law, arises when the prosecutor previously had represented the defendant, for example, with respect to an offense charged. Prosecutor might be disqualified, for example, if he is a fact witness in the case against the defendant. That couldn't happen, right? A conflict of interest could happen when the prosecutor has a relationship to a victim, maybe even a member of the grand jury. That kind of thing would be a conflict of interest. Conflict of interest leading to disqualification could exist when a prosecutor is compensated by a contingency fee that is paid only if a conviction is secured, because that fee arrangement creates sort of at least the appearance of a conflict of interest between the public duty to seek justice and a private right to obtain compensation for those services. And so none of those apply in this particular case. Let's talk about those in particular and why it is that the standards under Georgia law simply do not apply, and that all the things that you heard during the course of the past 2 days are irrelevant to the legitimacy of the prosecution against Donald Trump. There is no per se rule of disqualification based upon marital status in Georgia. The Georgia Supreme Court has even explained that even married couples on opposing sides of litigation do not suffer from a conflict of interest. The opportunity, if you will, for a conflict of interest, some potential impropriety between spouses on opposing sides of litigation are greater than those on the same side of the case working toward the same outcome. And that's what you have here. You've got two people on the same side of the case, not a conflict there, but a similarity, a symmetry, if you will, of interest. There is in the end no plausible argument that non-married attorneys who are together prosecuting a case, admittedly in a romantic relationship, who serve together in this role creates a conflict of interest for the defendant, robbing that defendant in some way of their right to a fair trial. Simply isn't there. The same applies to this issue about financial compensation that Wade may have received as a special prosecutor. Likewise, those kinds of things, they simply do not provide support for a finding by the judge of any problem here. The financial compensation paid to Wade is frankly consistent with some well-established practices in Georgia, does not give rise to a conflict of interest warranting prosecutorial disqualification. And again, publicly available documents, part of them presented during the course of this evidentiary hearing, are indicating that Wade's compensation was not contingent, of course, on the outcome of the prosecution against Roman or anybody else. Again, that is a system that it plainly would be contrary to fundamental justice movement, that somehow the prosecutor benefits financially if indeed there's a prosecution that is successful. In all of the years that I was a federal prosecutor, state prosecutors as well, you get paid by the state and your salary comes to you whether you are successful or not it is not contingent, not at all contingent upon the result, whether guilty or not guilty in the criminal prosecution itself. Again, the evidence presented about the Wade prosecution simply not relevant, not related to the legitimacy of the underlying prosecution. Concerns about whether or not somehow the issues here have been muddied in such a way that America now thinks that these are indeed relevant issues. In a related point, it's also significant that Roman's motion to disqualify also complains that Wade has never tried a felony RICO case. That's a part of his motion as well. And there again, as I said before, defendants do not have the right, the prerogative to choose their prosecutors. You can make decisions about employment that are good, bad, someplace in between. Again, those are personnel matters inside the DA's office. They may be issues for resolution by supervisors and others, but they don't have that connection, that relevant connection between what was going on inside the office and the legitimacy of the prosecution outside of the office. What is missing here of all of these cases, all these instances, including this personal travel issue, which we heard a lot about, is how, in fact, that has a substantive impact, somehow denigrates the prosecution of Donald Trump and the others, including Mr. Roman, in this case going forward in Georgia. When we come back, I'm going to make a prediction about what Judge McAfee does here in connection under Georgia law, in connection with the Roman petitions, and we'll talk about that and more right after this brief break.
WAUK, Waukesha's home for Up North News Radio.
It's Black History Month, and civic media supports the importance of this observance. But what do you really know about it? I'm Calvin Butenhoff, producer of The Earl Ingram Show. Our Echoes of Empowerment Black History Stories will offer thoughtful answers all month long. Now, here's Earl.
You cannot talk about Black history without including some of the early music and art which flourished in the 1920s and 30s, time now called the Harlem Renaissance. But this new Black cultural identity was growing everywhere. Trumpet player Louis Armstrong moved to Chicago. Painter Henry Tanner was accepted into the Academy of Design. Musician Robert Johnson recorded the Delta Blues in Texas. Listen for another Black history story right here on Civic Media. I'm Earl Ingram.
The Shaw, WAUK. The Shaw, WAUK. The Shaw.
Continue our analysis or discussion this morning of the evidentiary hearing that America was tuned into for the past couple of days, including the testimony of Fani Willis and her co-prosecutor, Nathan Wade, with whom she admitted she had a personal relationship, and asking the question, if not answering it this morning, of how this is relevant to any prosecution of Donald Trump, which does proceed, and most specifically, under what rubric, under what structure does any of this information about the financial relationship between them, the personal relationship between them, the compensation of Mr. Wade, all of that, what is the relationship between that and a reason to disqualify the prosecutor in the prosecution itself? The answer is that there is none under Georgia law. There is nothing about the forensics of this. There's no conflict of interest. There are no two interests that are conflicting here. Instead, there is simply allegations and perhaps even proof of personal relationships inside the office those do not affect the legitimacy of the prosecution going forward. And those of us listening and watching, including you, to the evidentiary presentations of this past couple of days, had to be scratching our heads collectively saying, what is going on here? If the judge is, in fact, simply attempting to make a full record for Donald Trump and for Mr. Roman himself, giving them the full opportunity, as he said once, to present your case, that is one thing. If, on the other hand, the notion is that somehow there is a legitimate, there's a there's something real here, this is a legitimate argument to make, the answer is no. This is nearly frivolous in terms of its presentation. And anticipate that Judge McAfee will soon, hopefully very soon, issue an order finding that none of the evidentiary presentations, while interesting, may be salacious, may be appropriate for coffee table conversation about what's going on inside the office, do not in fact constitute a conflict of interest for Fani Willis or her office that in any way deprives either Mr. Roman, Mr. Trump, or any of the other defendants of a right to a jury trial, right to a prosecution that is free from interference from anything that is inappropriate or wrong. That's simply not here. And so under Georgia law, as we have described it, all these things make clear that while this process perhaps had to be conducted as a part of the pretrial proceedings, it has been, as many people have said, a sideshow, a collateral issue, a footnote to what should be the focus, which is the substance of the prosecution as it goes forward. We hasten to add once again, Donald Trump and Mr. Roman, other people in this case who have not yet pled guilty, the presumption of innocence stays with them as all of this goes forward. Anticipate that Judge Scott McAfee hopefully will make short shrift of this, issue an order, perhaps an oral ruling, maybe a substantive written ruling about all this, but should come to a conclusion fairly soon. All of this, of course, a diversion, and also taking time away from the actual work of prosecuting and defending this case pending right now in the Georgia court. And this morning, some commentary about Wisconsin itself, coming right back home. We know from our previous discussions way back in December 22nd, our Supreme Court overturned the current maps that are existing for our recent elections here in the state of Wisconsin for the Assembly and the Senate, and ordered that parties propose new ones. The vote on that decision was 4-3. And in the wake of that, the court hired some academic consultants to analyze those proposals for new maps. It directed the parties on both sides to file memorandums of law, and all that has been going on. Lots of briefs and responsive briefs. All of that has come to a conclusion. Along the way, the consultants found that the plans offered by some Republican lawmakers and by a conservative policy group constituted partisan gerrymandering and should not be considered. The four remaining proposals, greenlit by the consultants, were submitted by the plaintiffs, by the office of the governor, by Tony Evers, by some Democratic senators, and also by some mathematicians and data scientists. So we've got lots of maps out there. And the Wisconsin Supreme Court, again, has taken all of this, if you will, under advisement based upon its commitment, as it said before, that if the legislature and if the governor cannot come to an agreement on their own, as they should under the normal process, then the Wisconsin Supreme Court will take this on, and based upon all the submissions, including the maps, including the statements by the lawyers, when all of that happens, they will then issue their opinion. Well, something significant happened this past week, as you have heard in the news, as you know, right here on the newscasts of Civic Media, and that is that just this past week, the legislature, led by the Republicans, adopted the voting maps that were drawn by the office of the governor, Tony Evers. And Tony Evers has said, of course, that he would sign that redistricting plan. It was passed unchanged. And earlier on, there was a bit of a skirmish about whether or not the plan, an earlier submission, did in fact constitute the governor's plan, the governor's maps, or if it would in fact accomplish some changes in that. It's very clear now that just this past week that the legislature passed the governor's maps themselves. And so the question now is, will the governor now sign this while this is pending also before the Wisconsin Supreme Court? Plainly, the governor has indicated that he intends to sign it. We'll see if he does that, anticipating that he does. It is also significant to note that even under the new maps, the maps that he may have presented, that the Republicans will still retain some majorities in both chambers, though the party's advantages would likely be similar than the absolute authority it now sort of commands, particularly in the Senate. And so the net impact of this, even with the governor's plan, may not be to shift power and responsibility inside the Senate and the Assembly, but nonetheless make the maps more fair in Wisconsin. The governor should sign that map. And I know that there is some concern among some members of the legislature, particularly on the Democratic side, about the possibility of getting an even better map from the Wisconsin Supreme Court. And I will say simply this, that in all the civil litigation, which this is, fundamental notion that if you can settle a case, bring it to resolution, which this would presumably for the next 7 years or so, always better to try to resolve a case outside of court, even though if everybody gives up something, the Republicans and the Democrats give up something they would otherwise have, probably a good result if everybody walks away with a settlement with which they're somewhat a bit unhappy. Common phrase, common adage out there in the civil litigation. And so we would anticipate the governor would bring this to a conclusion, the Supreme Court then not having to decide this issue. And America would look to Wisconsin and say there's a situation where the legislature and the governor did their jobs, fair maps in place for the at least remaining 7 years of our time. Next week, as in every week, we continue to focus on these issues of courts in America, American justice, government, and the aspiration for justice in Wisconsin, in our nation. Come back again next week for that important discussion.
Weekday mornings from 8 till 10 on The Shaw, 540 AM and 101.1 FM WAUK.
Hey, this is Dom from the Devil's Advocates. Tune in Monday, 4 to 6. Crudy's gone. Nate and I are holding down the fort. When the cat's away, the mice will play. Tune in, 4 to 6.
Finding the special healthcare resources families need just got easier. Wisconsin Wayfinder Children's Resource Network helps kids with delays, disabilities, special healthcare needs, and mental health conditions. Call toll-free 877-946